Good morning. Thank you everyone for joining. Welcome to the latest public law update. It's now been a regular occurrence. I think we're now on our third year of doing these public law updates once a quarter, led by ably by both Miranda and Charles. We're delighted to see so many of you joining the session today, and we hope you'll find everything useful and informative. Just the usual housekeeping points. Everyone's microphone is automatically muted, so you don't need to adjust your own settings. We very much welcome questions, and there is a Q&A box usually at the bottom of your screen, so please feel free to type into that as we go along. If you'd like to remain anonymous, then you can do so. There's a box to tick to say send anonymous. We will try and ask as many of those try and answer as many of those questions as possible at the end of our session today. The webinar will be recorded and you will be sent the link to the presentation shortly after the end of the event today. If your connection gets lost, just rejoin back in. We're very fortunate today to have both Miranda and Charles speak to us. Miranda is a very experienced member of the public law team. She has a broad public law practice with a particular interest in immigration, human rights and trafficking matters, and has recently been appointed at an extremely young age and Deputy Upper Tribunal Judge in the Immigration Appeal Tribunal. She will be too shy to tell you this, but I can indicate that she was nominated for Legal Aid Barrister of the Year last year. Likewise, Charles has a stellar career in public planning and environmental law. He is seen as a rising star in the Legal 500 and is listed in Planning Magazine's Top Juniors. He's regularly involved in a range of high-profile cases, the most recent of which was the challenge to the government's ban on puberty blockers in respect of a transgender youth interest group. We very much hope that you will enjoy this morning's range of cases, and I now hand over to Miranda to start her talk.
Thank you so much, Fiona, for your far too generous introduction. And thank you so much, everybody, for joining us today. I have a proper grab bag of legal updates for you. There's quite a range of cases that I'm going to be dealing with. I've given you some key themes, but there's, I'm afraid, no interconnected theme linking the 4 cases I'm going to be talking about. I should also flag that I'm not going to be covering the rather interesting cases that came out of the Court of Appeal on Friday after we'd all finalised our slides for today, but anybody who's interested in nationality or citizenship cases should certainly look at the cases of Chowdhury, Dachi and Kolikaj that have just come out of the Court of Appeal. And there's also a case about entry clearance for a separated family for people who are interested in immigration matters. But coming to my cases, we will be talking about what sort of decisions are amenable to judicial review, about a recent case on systemic breaches of Article 3 of the Convention in the context of no recourse to public funds, to the appropriate forum, particularly for certain trafficking challenges, and how to write to the court, probably the most important issue. But I'm going to start with amenability, and I'm going to talk about the Court of Appeal's decision at the end of last year in the case of Shashikant. The question here is quite technical, but it actually reminds us of some really important principles that we need to be aware of as public lawyers, identifying what decisions can be the subject of judicial review. In this case, the appellant was a GP who held contracts with the local clinical commissioning group. The CCG had terminated those contracts due to an alleged breach of a duty of cooperation. The Secretary of State decided to use a statutory power to refer this dispute to an adjudicator, and that adjudicator in turn held that the CCG had been entitled to terminate the contracts. The appellant then judicially reviewed that decision of the adjudicator, and the narrow question in this case was essentially whether that decision of the adjudicator was amenable to judicial review. At first instance, Mr. Justice Bourne said that both said that the adjudicator had made an error of law in analysing the contracts, but more significantly for our purposes, held that the decisions simply weren't amenable to judicial review because the choice of a contractual mechanism, namely referring the matter to an adjudicator, didn't introduce a public law element. So that was appealed to the Court of Appeal successfully. And the quite straightforward position that the Court of Appeal held was simply that in this circumstance, the adjudicator was a body exercising public functions and therefore amenable to judicial review. But essentially, this is going to be a question of substance, and the court reminded us that a decision will be, or an act will be subject to judicial review where it is undertaken by a body exercising power derived from statute, or where it's justiciable the prerogative. And decisions can also be amenable to judicial review where they have what the court referred to as a sufficient public element to make it amenable to judicial review. So to go back to the point I made earlier, this is very much a matter of substance, not form. It isn't a question of just looking at the nature of the decision maker. You need to look at what powers the decision maker has, what the source of those powers are, and what the nature of the function is. So one of the examples that the Court of Appeal notes is, for instance, if a police force decides to terminate the employment of a police officer, that is not going to be a decision amenable to judicial review, because that is not in substance a public function, for all that obviously the operation of a police force is very much a public matter. And the court re-emphasised the, I'm sure, self-evident proposition that judicial reviews have to deal with public law matters and aren't the correct forum for enforcing private law rights under contract or tort. And that is why your aggrieved police officer, thinking he's been unfairly dismissed, couldn't bring in judicial review because he has civil remedies to deal with that civil matter. Looking at the decision of the adjudicator in this case, the court held that the adjudicator was exercising a public function because they were appointed under the 2015 NHS contracts regulations, which allows the Secretary of State both to determine disputes and to refer those disputes to an adjudicator. And the court emphasised the presumption that where a power arises under statute and is regulated by statutory provisions, that is likely to be an exercise of a public function subject to judicial review. But that is only a presumption, it's a rebuttable presumption, and the court found in this case there was nothing in the nature of the adjudicator's decision which would rebut that. And the fact that private rights were at stake wasn't conclusive of the function. Private law rights can arise in a statutory context where the substance of the function is still public. And the court's conclusion here was that the reality of the situation is that medical services contracts concern a public function. This is about the provision of healthcare within a heavily regulated statutory framework, and the fact that there were potentially private law rights or disputes within that should not be conclusive given the public law flavour of this matter. Moving on to a completely different issue, the Article 3 systems duty. SAG was a case brought by 3 families. They were all migrants in the UK with limited leave to remain. The Secretary of State had imposed a no recourse to public funds condition on their leave. And all of these individuals had applied to the Secretary of State saying, we have been able to support ourselves so far with no recourse to public funds because we've had assistance from friends or family, but they're no longer able to assist us. Please, can you provide us with financial support? Please, can you allow us to access public funds in order to obtain the financial support that we need in order to avoid destitution? And the court reminded us of something that I'm sure everyone here will be familiar with, which is that Article 3, as well as the negative obligations underneath it, imposes a positive systems duty, requiring the state to put in place suitable systems that are sufficiently resourced to reduce the risk of inhuman and degrading treatment to a reasonable minimum without imposing an impossible or disproportionate burden. And in this case, the requests that have been made as part of a request to the Secretary of State to discharge her systems duty had been met by a request for essentially further information, and where that further information hadn't been immediately forthcoming, there had been delays and or refusals to lift the no recourse to public funds conditions, which the claimants complained left them in destitution, or at least at risk of imminent destitution. The backdrop to this was the defendant's own evidence that there had been a steady increase in the average time that it took to determine applications, potentially leaving people in destitution. So the court firstly held that the Home Office isn't entitled to just adopt a wait and see approach, just waiting to see whether somebody's support ends, and at that point stepping in and lifting the NRPF condition, because it is an obligation to act where there's an imminent risk of destitution, not where there is in fact destitution. So it is a preemptive and proactive duty. However, in these cases, where the decision maker had come back to the claimants and said, please, can we have some more evidence? Why is this third party who's been supporting you for several years suddenly saying they can't? The Secretary of State is entitled to seek that further evidence, and if that further evidence wasn't forthcoming, was entitled to take that into account lawfully as a relevant consideration. And the court emphasised that these decisions are going to be an intensely fact-specific assessment about the quality and nature of the evidence before the decision maker at the time of the decision. So obviously potentially erecting quite a challenging barrier for somebody there who perhaps is struggling to obtain evidence from their third party who's previously been supporting them. Notwithstanding that, the court did find that there had been a breach of the low-level systems duty under Article 3. And that's because that low-level systems duty, the duty to put in place a suitable system to reduce the risk of inhuman and degrading treatment to a reasonable minimum, includes a requirement to deal with requests in this context in a timely manner. And the Secretary of State's evidence that it was taking on average 70 days for these applications to be processed was, in the court's view, far too long, and it resulted in an immediate risk of people falling into inhuman and degrading treatment. In this case, the court concluded that the Secretary of State hadn't done enough to put in place a sufficient system that reduces the risk of destitution as far as practically and proportionately possible. And in particular, there was the possibility of case-by-case prioritization and triage, but the Secretary of State's evidence didn't show that this was more really than a sort of ad hoc responsive system, and the court was not persuaded by the Secretary of State's evidence and indeed submission that if people were in difficulty, they can make a complaint or send a pre-action letter, because that wasn't enough given the positive duty that sat with the Secretary of State. Moving on from Article 3 to the context of trafficking, there was a case that may have passed some of you by at the end of last year, which is, I think I'd put in the boring but important category. So the backdrop to this is the passage in 2022 of the Nationality and Borders Act, which made very significant changes to provisions for victims of trafficking, including introducing a new Section 63, which allows for people to be excluded from identification and support as victims of trafficking if the Secretary of State considers that they pose a sufficient threat to public order. And the question in ABW was quite simple. It was, if you're challenging one of those disqualification decisions, do you do it in the upper tribunal or do you do it in the administrative court? And I must say this is something that's arisen in my own practice too, and every time I go back and read the Lady Chief Justice's direction on the transfer of judicial review, I am reminded it could be a little clearer than it is, and indeed it did take the court a bit of time to wrap its head around it. But quite simply, what the direction says is that a challenge to a decision made under the Immigration Act or to any instrument relating to leave to remain or enter in the UK should be brought in the upper tribunal. The Immigration Acts are very broad, and they include the Nationality and Borders Act. But a decision made under Section 63 isn't a decision relating to leave to enter or remain in the UK, because whilst a victim, if not disqualified, may go on to receive a conclusive grounds decision and may after that be able to apply for leave to remain under Section 65 of the Nationality and Borders Act, there is no immediate link between a disqualification decision and leave to enter or remain in the UK. The court considered the direction and the nature of these decisions at quite some length. Mr. Justice Dove concluded that public order disqualification decisions don't have to be brought in the upper tribunal. The relevant question is the specialist expertise of that tribunal, its understanding of immigration, asylum, and often nationality matters. And given that this was not simply a decision relating to leave to remain or enter, the court wasn't required to conclude that any decision that was made under the Immigration Acts must fall within the direction. You had to look substantively at the decision in question before deciding whether something made under the Immigration Acts would potentially fall within the direction. And in undertaking that analysis, Dove pointed out that there are a very wide number of decisions, including decisions around, for instance, shipping and customs, that could be made under the Immigration Acts, which are not self-evidently the type of matter that the upper tribunal would have a specialist interest in. And then looking at disqualification decisions themselves, Dove found that these decisions, of course, can extend to British citizens. It's not just a matter of immigration control, because being a victim of trafficking is not restricted by nationality. There are other more direct consequences of a disqualification decision other than the possible loss of a route to leave to remain. And the fact that there is a sort of immigration backdrop to this could not be determinative. However, Mr. Justice Dove did emphasise that there's still a discretion to transfer disqualification cases to the upper tribunal where it's just convenient to do so. It's also worth noting that High Court judges can constitute themselves to sit as judges of the upper tribunal if necessary. It was also the case in ABW that case had been on foot for a very long time. And Ms. Justice Dove did leave open the possibility that in other cases, at a different stage and with a different focus, a different outcome might result. My view is that if you are simply challenging a disqualification decision and there's not some parallel challenge to a leave to remain decision, that you should be bringing them in the administrative court in light of this, even if they're at a very early stage, because essentially the reasons that the court gives in ABW are likely to apply in most disqualification challenges, but I would also say this is something you want to turn your mind to when you're making a decision as to where to issue disqualification challenges. Finally, I'm going to talk about how to write to court in urgent cases, something that I know we all worry about. This case involves a serious foreign national offender who had made a lot of fruitless applications trying to prevent his removal late last year. This resulted in removal directions being set early this year. And when that happened, he filed a further claim acting as a litigant in person challenging his removal. That was unsuccessful, but that's not the material issue here. The material issue here is that very shortly before he was due to be removed, after he'd filed his application for an injunction acting as a litigant in person, the government legal department wrote to the administrative court by way of an email headed strictly confidential regarding Mr. Jesse's case. That email was not copied to Mr. Jesse, and it contained essentially two elements. One element was essentially saying his removal is going to be at this time by a charter flight. We have counsel available. If you wish to have a hearing on this matter, we are here to assist the court. But it also adduced multiple files of evidence that it wished the court to consider. Mr. Justice Chamberlain picked this one up and wrote a very stern judgment, which reminded us all of what CPR 39.8 says. And I'm sure everybody here has memorized CPR 39.8, but for those of you who might not have it off the top of your head, essentially, it provides that any communication between a party to the proceedings in the court must be disclosed to, and if it's in writing, must be copied to the other party or their representatives, save in very limited circumstances. Those circumstances would either be where it is routine, uncontentious, or administrative. I've been trying to think of examples, and I was thinking potentially something such as, please can I check judge's clerk whether you received my last email, something as simple as that. Or where there's a compelling reason not to copy in the other side, and that reason is clearly stated in the communication. Obviously, there are specific exceptions under, for instance, the closed materials procedure, which authorises a party not to disclose material to the other side. But of course, those are bespoke rules that wouldn't apply in this context, and certainly didn't apply in Mr. Jesse's case. In this case, Mr. Justice Chamberlain said that the email that was sent right before the hearing plainly contravened those principles, because it was about a particular case. It was sent after proceedings and an application for interim relief had been issued. It went well beyond a routine, uncontentious, or administrative communication. It contained submissions, in particular, on what had happened in previous litigation, including allegations that the claimant had made material non-disclosure. And there was, in Mr. Justice Chamberlain's view, no compelling reason for not copying the email to the claimant. So the possibility that that somebody might seek to disrupt a charter flight could be a reason in an appropriate case not to disclose the time of the charter flight itself to that person or to the public more widely, but that doesn't justify wider non-disclosure, especially of pertinent evidence and submissions that you're inviting the court to take into account. So Mr. Justice Chamberlain tells us that in future, if emails like this are received by the administrative court, they should be returned to the sender, and that sender should be referred to a judge for consideration as to whether sanctions should be imposed or other case management direction should be given. It is not problematic for the government legal department to make a private communication to the court on a general basis, saying a charter flight is leaving on this date at this time. That is a strictly confidential matter. Here are our GLD lawyers and counsel instructed to deal with this matter. In those cases, there's not a party to the proceedings. There's not a claim on which you're filing evidence or making submissions, and you're simply assisting the court in those circumstances. But once proceedings are issued, not only do you have to comply with CPR 39.8, you also need to keep under review, as a matter of the duty of candour, whether it is in fact appropriate to withhold the intended departure time from the other side. And Mr. Justice Chamberlain comments that it might be appropriate, even if it's felt that there's such a risk of disruption if the time is disclosed, to provide a not before time to assist both the other side and the court with appropriate case management and listing times. I'm now going to hand over to Charles, who I'm sure will have many other interesting things to cover.
Thank you, Miranda. And well, I suppose it's not too late to say Happy New Year to everyone. Thank you for joining us today. I'm going to be covering three topics in public law. The first is not strictly about public law only. It would include any area of civil procedure which has capacity to litigate. The second is relating to the availability of alternative remedies and what that can mean for bringing a judicial review claim. There was an important Supreme Court decision on that last year. And then the third is relief and the making of mandatory orders. So turning to capacity to litigate and the civil procedurals, I just want to go through some of the basics, really, that sort of a recap. So as a reminder, a party or an intended party who lacks capacity to conduct proceedings is known as a protected party within Part 21. And lacks capacity means lacks capacity in the Mental Capacity Act 2005. And a protected party must have a litigation friend to conduct proceedings on their behalf. And a person may not, without the court's permission, take any steps in proceedings except issuing and serving a claim form or applying for the appointment of a litigation friend under Part 21 until the protected party has a litigation friend. Further, if during ongoing proceedings a party lacks capacity to continue to conduct proceedings, no party may take any further step in the proceedings without the court's permission until the protected party has a litigation friend in place. And any step taken before that has no effect unless the court orders otherwise. Now, how do you assess capacity to litigate? Well, there was a case in 2023 in the Court of Protection, which set out the approach that the court will take. That's the North Bristol NHS Trust case. There's particular provisions within the Mental Capacity Act that go about assessing whether or not someone has capacity. And the relevant question is whether at the material time, the individual is unable to make a decision for themselves in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or brain. And what does it mean to be unable to make a decision for yourself? Well, it means that you're unable to understand the information relevant to the decision, retain that information, to use or weigh it as part of the process of making the decision, or to communicate the decision, whether by talking, using sign language, or any other means. So it's any of those. It's that you don't need to lack one of those. Sorry, all of those. It's you only need to lack one of those. But a person must be assumed to have capacity unless it is established that they lack it. But where there is good reason for for concern and legitimate doubt as to capacity, that presumption shouldn't be used to avoid taking responsibility for assessing and determining capacity. So really, sort of two aspects to the test. There's something called functional test, so whether or not that person is unable to make a decision for themselves. And then there's something sometimes called the diagnostic test, which is that because of an impairment of or a disturbance in the functioning of the mind or brain. But diagnostic test is liable to confuse because you don't, strictly speaking, need diagnosis in order to have an impairment of or a disturbance in the functioning of the mind or brain. And I'll come back to that in a minute. So the burden of proof lies on the person or body asserting a lack of capacity, and that person or body might not necessarily be a party. It could be the legal representatives, for example. And the standard of proof is the balance of probabilities, and it's required to be assessed in relation to the specific decision at the time the decision needs to be made. And there isn't such a thing as capacity to make decisions generally. So when we're talking about what is the matter for the purposes of assessing capacity for litigation, it's to make a decision in relation to those proceedings. It's not about, well, how is their ability to bring a different kind of litigation down the line. So generally, the question whether an individual's inability to do the various things to make a decision is caused by an impairment or disturbance in the functioning of mind or brain requires evidence from a suitably qualified person, which would usually be someone with medical qualifications. That's from the Masterman Lister case of 2002. So normally you would expect to have some kind of medical report, but strictly speaking, no formal diagnosis of impairment is required. You don't have to have a capacity assessment by a psychiatrist. And so there might be cases where you can conclude quite safely because there's clear evidence of some kind of mental impairment, and it's obvious that that is causing an issue with functioning. Or it might be that there's been a historic diagnosis, say, for example, of some quite significant mental illness from a young age, which means that there is no need to carry out a further capacity assessment because the evidence is so overwhelming. So that's what the legal test is for assessing capacity, but how is it actually determined as a matter of procedure and practice? Well, something that can happen is that a legal representative might have doubts about the client's litigation capacity. And if that happens, then you are under a professional duty, either under the rules of the SRA or the VSB, depending on what lawyer you are, to resolve the issue as quickly as possible by investigating the issue for yourself, and if necessary, and usually, and in particular, if the client themselves are saying, well, actually, no, I think I do have capacity, raising the issue with the court. And that comes from a 2008 case in the Court of Appeal. And this is a really important duty because you have a duty both to the court and to your client in these situations. But what happens if you've got this doubt about your client's litigation capacity? Something needs to happen in the proceedings, but you don't yet have any evidence as to capacity. So you've got a doubt, but you're not sure that your client lacks capacity. Well, if to litigate within the strict meaning of the Mental Capacity Act. So you might think, well, okay, yes, I think they are struggling to be able to understand the decision they've got to take, but I don't know whether that's because of a mental impairment. It might be that they're just struggling, and in which case that is not sufficient in order for them to be considered to lack capacity. Well, as I said, there might be cases where it's so overwhelming that you actually don't need medical evidence to make that determination, but there will be difficulties if you can't be sure of the position. And the problem is that there is no procedure in the civil procedure rules to determine capacity where it is in doubt because of difficulties getting medical evidence. So this most often would arise in situations where there's actually no funding to obtain a capacity assessment, but it could also happen where, as I indicated, the client themselves doesn't cooperate and doesn't want to undergo a capacity assessment because they consider they do have capacity to litigate. It could also happen in situations where an urgent step needs to be taken and there just simply isn't time to obtain a capacity assessment in that time because there aren't, for example, any clinicians available who could carry it out. Well, I'm afraid I don't have any easy answers to that question, apart from to say that this problem is now well recognized and documented by the Civil Justice Council in a really excellent report, which was published in November last year, and which suggests amendments to the civil procedure rules to deal with it. I understand from speaking to someone who's involved in that report that there hasn't been any further progress since that was published. So we are, I suppose, just very much hoping that the Civil Procedure Rules Committee is going to pick that up and implement the changes that are needed. But in the meantime, what are you to do as a practitioner? Well, it may be possible to make an interim order appointing a litigation friend to allow for evidence to be obtained and for steps to be taken in the interim. That has happened in the family court in a published case, which I've put on my slide, where an interim order was made to allow the official solicitor to be instructed. There isn't any published judgment that I'm aware of or anyone I've spoken to is aware of where such an order has been made under the civil procedure rules. However, in a case I did in the day after the Civil Justice Council report was published, I obtained such an order in a judicial review on an interim application in circumstances where the matter was so urgent that steps needed to be taken in the litigation. It was a case involving homelessness, but it was impossible to get a capacity assessment in time. And Michael Ford KC, sitting as Deputy High Court Judge, made the order relying on CPR Part 25. So it may be possible to obtain that in your case if you've got particularly compelling evidence. As a matter of law, the existence of Michael Ford KC's judgment isn't necessarily going to be able to be relied on by other judges, but it might give them some comfort if you had a case where this was important. You could could note that it has been used. But we really hope that the Civil Justice Council recommendation will be implemented soon to find a way through, because these issues do keep coming up in other cases. So that's capacity. Moving then to alternative remedies. Now this, I'm essentially summarizing a decision from the Supreme Court in October last year, emerging from Northern Ireland, but its principles would have application in England and Wales as well. So just kind of going back to basics again, availability of judicial review procedure is discretionary. A court may refuse to grant permission or to refuse a remedy at a hearing if a suitable alternative remedy exists and the claimant has failed to use it. It is not like other areas of private law where if you have a cause of action, you are legally entitled to a remedy that marries up with that cause of action. Judicial review is discretionary. It is up to the court. The judicial review procedure is a remedy of last resort to ensure that the rule of law is respected when no other procedure is suitable to achieve that objective. And that's from the Glencore Energy case. So that's important context for understanding how the court is going to approach alternative remedies. And the most obvious alternative remedy is where you have a statutory scheme for appeal in respect of certain decisions. And generally, an appeal would ordinarily be a suitable alternative remedy. There are situations where that wouldn't be the case, for example, where you are arguing potentially that an aspect of the statutory scheme is itself unlawful. That might not be possible to be able to be argued on appeal, but it could be in a JR context. So that might be one area, depending on the facts and the legislation in place, where an appeal might not be a suitable remedy, but that's going to be a sort of rare and extraordinary case. So what was the case about in the Supreme Court? Well, it was a judicial review of various regulators of a waste disposal site, and the claimant, Ms. McAleenan, who lived near the site, argued that the regulators hadn't taken appropriate action to prevent harmful chemical gases and noxious smells escaping from the site. But the regulators argued that, well, actually, this isn't really for this court to deal with, because Ms. McAleenan had adequate alternative remedies, because she could have brought a private prosecution or a nuisance claim in private law against the site's owners. And the Court of Appeal agreed with that, and also noted she could have also complained to the Northern Ireland Public Services Ombudsman. But the Supreme Court disagreed with that, and the judgment is really interesting on this issue of alternative remedies. It's been quite some time since this matter was looked at by the Supreme Court, and it's really useful read. I would recommend it. The court approached this question by considering what was Ms. McAleenan's objective. And while it was correct to say that her overall objective was that noxious gases would be prevented from escaping the site, there were different forms of legal proceeding available to her which might have led to that outcome, each giving rise to different issues and each with their own risks and costs. And the Court of Appeal had assessed her objective at too high a level of generality, at that high level of saying, well, she just wants the noxious gases to be stopped. But actually, her immediate objective in the judicial review was to seek to compel the defendant regulators to carry out their duties, not to seek relief from the wayside. So it wasn't that she was sort of looking for damages from the wayside. She wanted actually the regulators to do their statutory duty. And the Supreme Court said she was entitled to choose which claim she wished to bring. So she might have assessed that her overall objective was better promoted by ensuring the regulators did their job properly and brought their resources to bear on the problem. And she can choose which form of claim to assert and against whom. And the court rules upon that and doesn't say that she should have sued someone else. So it's a case quite interesting, sort of putting the claimant back in the driving seat and understanding what the purpose of a judicial review claim might be. It might be about more than just kind of ensuring that the gases are stopped. Actually, she might be trying to get the regulators to do their job as well. So the question of whether a claimant has a suitable alternative remedy falls to be addressed by reference to the type of claim that the claimant's chosen to bring and what relief they have sought against the particular defendant. So in this case, a private prosecution or a civil claim for nuisance would not actually address the failure of the regulators to comply with their public law duties. Actually, it would probably have the opposite effect. It would probably allow the regulators to kind of get away with not complying with their public law duties, if that is what has happened, I should say, because there was not actually a finding that they had breached their public law duties. That had been left to be determined at a later point. And also there was sort of procedural aspects to this. So judicial review is a comparatively speedy, simple and cheaper process. So there was no good reason why Ms. McAleenan should be expected to take on the additional burden associated with a civil claim or private prosecution, when she could have so much quicker method to get the regulators to comply with their duties. And the court emphasized the important public law context of how regulators operate in a really interesting passage, which kind of goes into the heart of what I was just talking about, which is that regulators are given public law duties and they have a responsibility to act in the general public interest to ensure, in this case, that landfill sites do not give rise to harmful pollution and nuisances which affect individual citizens. And protection of people like Ms. McAleenan is part of their job. And they're given resources to take effective action where individual citizens might not be able to do so. So it can't be right for a regulator to then say, in response to a judicial review claim, that to carry out its duty in the public interest, well, the individual member of the public should take action themselves to address the problem. That would be entirely contrary to the statutory purpose behind what the regulators are there to do. Court then looked at the argument that there was a complaint to the ombudsman available, the Public Services Ombudsman. And the general position is that the opportunity to complain to an ombudsman does not affect the right of an individual to bring a judicial review claim against a public authority, because the role of an ombudsman is intended by Parliament to supplement control of public authorities by the courts through judicial review and not to replace it. Just pausing, would note that this judgment also has some interesting sections on how factual assessments arise in judicial review and what the court is looking at when it is determining or not determining factual questions, because the Court of Appeal had sort of gone a bit wrong in their understanding of that. I don't have time to go through that in this presentation, but if you're interested in that question, I'd take a look at the judgment. So turning to my final topic now, which is question of remedies and relief. And I'm going to look at this case AYW, which was a judicial review of the failure of the Secretary of State for the Home Department to provide adequate asylum accommodation in breach of her obligations under the Immigration and Asylum Act 1999 and some other legislation as well. And the claimants in this case were both disabled, and their current hotel accommodation was not appropriate for the second claimant's needs, who was particularly severely disabled. The Home Secretary admitted she was in breach and said, yeah, these claimants require accommodation with a wet room and wheelchair accessibility. But she said, well, I can't comply with any order to make me do that because it's not possible to do it. And the court then had to look at the principles which were set out by the Supreme Court a couple of years ago now in the Imam case, which explains when a court is considering whether to grant a mandatory order. So those principles were summarized by the judge in AYW. And starting point is, if a duty has been breached, then you've got to look at the terms of that duty and whether it is qualified in any way in terms of resources. So is there something like best endeavors or something like that? But if there has been a breach of the duty, the court should not modify or moderate the substance of what Parliament has decided this public authority should do by routinely declining to grant relief to compel performance on grounds of the absence of resources, because that would have the effect of undermining parliamentary sovereignty. But where a duty of a breach is established, the ordinary position is a remedy should be granted, and a court should be cautious before not doing so. But there are different types of order, and it might be that something else could work rather than a mandatory order, so a declaration might be appropriate in certain cases. But when considering whether to make a mandatory order, the court has to have regard to the way in which that order might undermine, to an unjustified degree, the ability of the authority to fulfill its functions. So would the effect of a mandatory order in this case then undermine the ability of the authority to comply with its duty in other cases? And the court should not make a mandatory order to require compliance with a statutory duty where it is impossible to comply with the order. So that was the argument being put forward by the Home Secretary in this case. the onus was on the defendant to establish impossibility. They've got to provide evidence, and a court will not be persuaded it's impossible to secure suitable accommodation unless satisfied all reasonable steps have been taken. And there are 5 non-exhaustive factors which are relevant to the question of whether resources are adequate to comply with the duty, and those were summarized in another case. So the first is need for contingency planning. So it's not enough to say, well, you know, there was some unexpected increase in our duties, and so we don't have the resources to comply with it, because the point is, if you've got such statutory duty, you've got to make sure you've got the resources in place allocated so that you can deal with kind of ebbs and flows. If you've been put on notice in the past of a problem in relation to non-performance, but you fail to take any opportunity to react to that in good time, that would be a relevant factor. The impact on the individual is also important. So it's the vindication of their right which is being denied. And so if there's a sort of very serious breach, then that might be important. But also what steps have been taken. So if there's no sign that the authority has done anything to rectify the situation, then that would be factor in favor of making an order. But in such a case, the imperative is to ensure the authority is taking effective steps to meet the obligations. And also there's another point, which is not to cause unfairness to others by prioritizing the claimant. So like I said, it could be the case that the court intervening in this case, it's going to interfere with the authority's ability to comply with its duties in relation to other cases which are not before the court. So how did this play out in relation to this case with the claimants who needed a room with a wet room and wheelchair accessibility? Well, the court did not accept the Home Secretary's argument it was impossible to comply with the order, and the judge, Tom Little KC, sitting as Deputy High Court Judge, gave 6 reasons. The first was, well, there was no reason in this case to depart from the ordinary position that a mandatory order be made, because Secretary of State had actually been in notice of a breach for a year. There was no evidence of any efforts to secure accommodation before September of last year, and limited evidence that she'd done anything after that. And there was actually also limited evidence as to the number of properties available in the required area, because the accommodation needed to be in a specific area of London and also of this particular type. And she was saying, well, it's impossible to find one. But the claimants actually in that case had provided screenshots of something like Rightmove, showing that actually there were available properties in the area. There weren't many, but there were some. Also, although there was this particular type of accommodation needed, it wasn't actually a particularly complex type of accommodation. And the Secretary of State had relied on the fact that, well, Clear Springs, their private contractor, was kind of not coming up to scratch on this. But of course, that's not a good reason to not make an order. And, in essence, there basically was nothing close to persuading the judge it would be impossible to comply with it. They didn't even have any evidence from Clear Springs to substantiate that quite high, suggestion that it's impossible to do this. And what was quite interesting, and I think important for anyone who works in this area, was to note that the court said this was actually not an isolated incident or outlier. And the court cited a number of cases from the admin court, which had made other observations that are critical of the approach taken by the Secretary of State in cases that were relevant to this claim. So if there are systemic shortcomings, that's a reason to make a mandatory order, providing it's not impossible to comply with its terms. It's not a reason to not make the order. So if this is a wider issue, that's actually an indication that really should make a mandatory order. The failure to make the order failure to comply with the duty was having an effect on both of the claimants, and making a declaration essentially, in essence, would not meet the justice or the injustice of the case. The chronology of the case was proof of the need for a mandatory order. Refusing to make an order or adjourning for 3 months, which was another suggestion by the Secretary of State, would just not be correct in those circumstances. So that's all I've got for today. I think we now have some time for questions.
Yes, we've only got thank you, Charles. We've only got one question, and which says as follows: given the alternative remedies case, I'm assuming the McAleese, the Northern Irish case, where do public authorities stand in arguing that a JR claim is premature in the absence of a claimant pursuing other avenues first, including the Ombudsman? Is an argument relying on the existence of an Ombudsman complaint now dead in the water? I've got my view. I'd be interested in what your two's views were first, though.
I don't think it's dead in the water. I think it's going to be quite a fact-sensitive case. It depends what remedies that ombudsman might have available, what that could lead to, and also how serious the matter might be. Or trivial. I think that would be an important factor, although maybe it isn't strictly speaking one. I think it would be something that would play on the mind of the court.
Having remained silent for nearly 45 minutes, which if anyone knows me knows is almost historically impossible. My view is that the Ombudsman does something a bit different to JR. And so I don't view the Ombudsman as an alternative remedy, but as a different form of remedy. I mean, for example, if what you're really looking at is to get your money back, for example, you wouldn't go to the administrative court because in the vast majority of cases, there's no kind of duty for them to pay private law damages, absent issues like restitution. So I always view an ombudsman as a sort of different form of remedy for something a bit different and for things which you really can't JR largely, or you do it after you've done the JR as a kind of follow-up. So, you know, the court has said this, but there's this and this issue which can't be dealt with. Miranda.
I really agree, Fiona. I think if you have a strong view that actually what somebody wants will be better served by them pursuing the ombudsman route, obviously you can say that in pre-action correspondence, but I actually think given the tight timeframes for limitation, if that's your view, you'd actually be better off proposing a stay post-issue and saying, look, we think that the meat of your complaint could actually be dealt with more proportionately here. But overall, I'm going to agree with Fiona that in most cases...
But don't forget as well, both the local government ombudsman and the public and health service ombudsman have a clause within the statute which says you can't bring an ombudsman claim if you've got a JR claim or an alternative private claim on foot. So it's not an alternative remedy in that respect for identical things. You have to kind of make your choice. Somebody's added a further update which says in re McLennan, was the regulator's breach an ongoing breach, i.e. would a JR claim remain available on an ongoing basis or be time limited?
It's ongoing because it was about a failure to take action, so it would have been available later.
Yeah, I mean, there are always issues there, aren't there, which are incredibly fact sensitive about how long is too long and whether or not you should have brought something at an earlier time if you were on notice that that was the position, which can sometimes be argued in those sorts of cases. But I mean, it would seem to me in something that it's really smelly. It hasn't stopped being smelly, has it? I mean, that's the essence of the case. It hasn't stopped being smelly. So there's the ongoing failure. Yeah. Okay. Does anybody else have anything? Does anybody else have any other questions? I was just going to ask you, Charles, about the capacity issue, which is this idea of making an interim order. What's the basis upon which that's done? Is that just using the inherent jurisdiction of the court? Because obviously the Mental Capacity Act has a specific power to make an interim order under Section 48. There isn't such specific power as far as, I mean, other than maybe the general powers of the Senior Courts Act to make declarations and things like that. On what basis are they saying that an interim order could be made?
So this is one of the issues and why the CJC kind of says we need to address this. So I think it's probably a combination of all of those things. I also think there's probably quite a strong argument that Article 6 ECHR requires that. And so I think that read with the inherent jurisdiction would work. I think there's sort of various ways you could get to that point, but there's also some ways in which you could kind of protect against any procedural irregularity, because the point is that the court could kind of subsequently ratify any steps that have been taken. So I think you've got to talk about, well, what's the risk here? What's the risk? The risk is, one, we are appointing litigation friend in circumstances where actually the individual didn't lack capacity. Well, if the individual actually is happy to go along with everything the litigation friend, proposed litigation friend, wants to do anyway, and indicates that to the court, then there's very little risk of any rights being breached in that situation, because actually if they did have capacity, then they were the ones in the driving seat anyway.
Yeah.
So I think that's how you've got to approach these cases. You've got to think about, well, what's the risk here?
Yeah. That seems very sensible. Now, we've got a case here, which I think relates to one of Miranda's cases, which says, do cases like BS and the Scottish Ministers and the Law Society and the Lord Chancellor and the AYW case give rise to cause for concern in relation to public funding decisions?
You see, there's a follow-up question about whether there's encroachment
in relation to encroachment on the principle that the executive is best placed to make decisions in relation to economic policy.
Yes, I don't have that concern. I think that what we see from the cases mentioned, but also actually I would say the SAG case, is that even in the context of fundamental rights, where the court is the primary decision maker and where it has an obligation to apply anxious scrutiny, the court is constantly highly mindful of its own limited expertise in matters of socioeconomic policy and of not putting what's referred to in SAG as an impossible or disproportionate burden on the state. And I think that, yes, for instance, in the Law Society case, you're talking about, you know, the court being quite courageous in standing up for common law principles of access to justice. But I think the court in that context would suggest that it has an institutional competence to understand what fairness looks like, and fairness will require some money to be spent. But I wouldn't say that I see the wind blowing away from deference to the government on matters of economic policy.
No. And I think that will continue to be the case, particularly given the funding crisis, this public spending crisis we are now in. I think I think cases which involve access to lawyers and access to the law, judges seem to treat in a slightly different category to access to anything else, as you quite rightly pointed out, Miranda. They tend to adopt a much more forensic level of scrutiny, shall we say, as to the indications made by the government. I mean, that dates all the way back to the Unison case, which was what, I suppose, about 10 years ago now. Gosh, I feel old when I say things like that. So yes, I think the courts will continue to be deferential, but there is obviously a level below which the court will say you can't use that argument if we're talking about Article 3 issues and Article 2 issues in circumstances.
Absolutely.
Yeah. Right. Well, thank you all very much. Thank you in particular to Miranda and Charles, who, as always, provided excellent content. I thank both of them, and I am so grateful that they are both members of my set of chambers, so I can rely on them for all and every matter. And thank you all for attending. We've got very good level of attendance, as always. So we look forward to seeing you at our next public law update, which will be in around 3 to 4 months' time. Thank you so much. Have a lovely